topic I want to talk about is with Americans, especially from a public point of view. Of course, famous.
How many other movies can you think of like trials? Few good, military trial, but a great one of the best.
Time to Kill.
Time to Kill. bunch of John Grisham ones. What else? What? Runaway Jury. Right. My Cousin Vinny. Actually, My Cousin Vinny has one of the best. It has one of the most realistic what trial is really like, and what cross-examination is really like. You show them pictures. Yeah, it's great. Most trials, and most of the ones we've mentioned, are criminal cases because, of course, you're doing a movie. You know, somebody's life and liberties at risk and build up a lot more drama. They're just suing each other for money that the insurance companies can pay. But there are some civil, because that's what I've been doing all my, these are some of them, the verdict, civil action, Robertson, Aaron Brockovich, Philadelphia class action, Rainmaker. These are the major blocksters in civil trial cases. Now, look at those six, what do all six of them have in common? And the answer is not a jury trial because in Aaron Brockovich, the plaintiffs and defendants actually decided to go to arbitrators and got a real big verdict, local utility, and arbitration that had juries. And the answer is the star always the plaintiff's attorney. The star never represents a company or an insurer. Those are always the bad guys. I used to be able to say that there's absolutely no movie ever made by Hollywood where the hero represented a corporation. In fact, there is one now, Clayton, starting with George Clooney, which I had. He becomes the hero by enticing his client to commit a felony while he's wearing a wire against listen in. Now, you will not only lose your bar license if you do that, you will go to, it breaks the wiretapping laws, it breaks all kinds of laws. All you have to do to be a hero as a defense attorney is go to prison for it, and then the Hollywood will be sad. Now, is it cause left-wing conspiracy in Hollywood? Yeah, of course it's yes, everybody knows that. I know that, but these were all blockbusters. So this was conservative people went to meet these movies. You go to movies where the hero is always the plaintiff's attorney. And the answer is because that's the way Americans think. If you think about it, all sports movies are the same thing. How many sports movies have you seen where the heroes were the team from the biggest high school? No, it's always all high school. That's who the hero is because all Americans, it's the individual versus the corporation, the David versus Goliath. That's the way Americans think. And that has an effect on trials because but most people, when they complain about sports, they're thinking about these 9 people. How many of you highly educated? It's one of the best universities in America. Can name all 9 members of the United States. This one's easy, of course. John Roberts. Stevens. John Paul. Very good. Most people don't get that one. Scalia. Antonin Scalia.
Anthony Kennedy.
Anthony Kennedy.
Thomas.
Marvin's got a ring crowd. See how many in the red are. The lady.
Ruth Ginsburg.
Right? This is the one. Stephen Breyer. This is the one that almost nobody knows. Former football. And the reason Sam Alito. Now, the reason they're more controversial is because they reverse. They find cases unconstitutional. They find statutes unconstitutional. This is the graph. Federal law unconstitutional. You'll notice that for the first 50 years, they held one case unconstitutional, one federal law unconstitutional. Anybody know what the case is? Marbury versus Madison. That's that case right there. That was one time in 50 years they held the law unconstitutional. The second time they did is that case right there. Dred versus Sandford started a civil war. They declared the fugitive slave law during compromise unconstitutional, said it was unconstitutional to restrict slavery in the new territories. That is what held America together for years before the Civil War. The fact that they split in the northern territories weren't enslaved, and the Supreme Court declared that law unconstitutional. That led to brass gag, debates, and ultimately the war. So there's great history on declaring law unconstitutional, but you see, as time went on, they got into the swing of things, and if you add state laws and laws held unconstitutional, it's much more packed this in because until 1920, nobody thought the Bill of Rights applied to anything except the federal government. 1920s, I think it was, getting over to New York the first time approved as the First Amendment also applied to states. Probably know the First Amendment never applied to states. Massachusetts had a state church till 1835, so you paid taxes. The government hired the preachers of the congregation church despite the First Amendment because nobody thought the First Amendment applied to states. In 1920, the Supreme Court discovered and then really started doing it in the 60s, 50s, and 60s in the Warren Court era that the 14th Amendment, which does apply to states, says state can deprive any person equal protection. Well, what does due process mean? Well, it means the rights, except of course two provisions which has not been incorporated. Second Amendment, we're waiting to see if they're going to out this year. The Second Amendment is incorporate the previous case in D.C. was easy because the Second Amendment applies to all proper federal places like District of Columbia, but does it apply to Chicago? It only applies to Chicago through the 14th Amendment. We're going to incorporate the Second. And the other one, interestingly enough, that they've never incorporated states is the Seventh Amendment, right to jury trial. And a civil case, Constitution as written, right to jury trial in criminal cases only. There's been hubbub in Massachusetts and Virginia especially, New York, so they promised to add, not a Bill of Rights, to add amendments, which became the Bill of Rights. They actually proposed 12 and only 10 of them passed. But that's where the right to jury trial in civil cases came in. Interestingly, from the Federalist Papers, Hamilton thought that the Constitution detractors say heirs and usurpation be uncontrollable and remediless. And he assures the reader that the Federalist Papers that won't be the case. A lot of people think he just got it wrong. There is no check on the Supreme Court. They talk about unconstitutional. You have one remedy. You have two. One, you replace enough judges to change their minds, and the other one is to amend the Constitution. The interesting thing about the Prop 8 trial out in California right now is the claim is you have to amend the Constitution of California to change the ruling they made on gay marriage that was required by the state constitution. Detractors are finding is exactly it could be unconstitutional to amend the state constitution. Seems like